Okay. Good morning, everyone. Welcome to the Maryland Public Service Commission's administrative meeting for June the 13th, 2018. I would also like to welcome you to the Honorable Frank Hines hearing room. We had our dedication yesterday, and it was fantastic. So we're happy to now be in the Frank Hines hearing room. I have some very happy news today. We have a new employee I want to introduce, Ms. Margaret Tubridy. Margaret, can you please stand up? We want to welcome Margaret to the Telecommunications, Water, and Gas Division as a regulatory economist. Margaret is a recent graduate of the University of Maryland College Park with a degree in agricultural and resource economics, focusing on energy and international business. During her undergraduate career, she interned with various environmental nonprofits, completed a fellows program for the Federal Energy Policy, and later interned at an energy efficiency consulting group. Her most recent contract in energy efficiency consulting resulted in over 10 formal recommendations for new appliance efficiency standards to policy makers in the state of Washington. I think we have Margaret in the wrong division, given her great background in energy efficiency. But for now, we'll leave her in the Telecom, Water, and Gas Division. Margaret, we look forward to working with you. Okay, let's move on to our administrative agenda.
There are no consent.
Actually, before we do that, thank you, Commissioner Richard. I forgot. We have a draft minutes from the administrative meeting for June the 6th, 2018. I'll move to approve the minutes. Is there a second?
Second.
All those in favor signify by saying aye. Minutes are approved. On to our administrative agenda.
Thank you, Mr. Chairman. There is no consent agenda today. The first item on the administrative agenda is Hilltopper Wind Power LLC and L Green Power North America filed on May 24th, 2018, an application for certification as a renewable energy facility for the Maryland Renewable Energy Portfolio Standard Program.
Good morning, Mr. Chairman, Commissioners. Kenneth Alpert on behalf of staff. This item addresses a filing by Hilltop for certification of its wind energy facility as renewable energy facility. Under COMAR, a facility that wants to obtain renewable energy credits for the renewable attributes associated with its electricity generation must be certified by the Commission as a renewable energy facility. Hilltopper's facility consists of wind turbines in Illinois, and that is within the PJM region. The maximum capacity of the turbines is 185 megawatts. Staff recommends that the Commission certify Hilltopper's generating facility as a renewable energy facility.
Thank you. Questions? Commissioner O'Donnell.
Thank you. I appreciate staff noting the Illinois facility of 185 megawatts. Do we have a sense of ballpark how much money this 185 megawatt wind farm in Illinois will generate for Maryland in terms of RECs?
Good morning. Matt Bonikowski on behalf of staff. So it'll depend on the number of RECs that are actually sold in Maryland. Some back of the envelope calculation says if 100% of the RECs generated were sold in Maryland, it would be about $4.2 million in value.
And is that an annual figure?
It is.
Annually $4.2 million going to Illinois?
100% were sold.
Okay,
yes.
Thank you, Mr. Bonikowski. I appreciate it.
Any other questions? If not, do we have a motion?
Mr. Chairman, I move that we approve the application and issue a renewable energy facility certification number, direct the company to establish a REC account with PJM GATS within 30 days of certification, and direct the company to file notice with the Commission within 30 days of any changes to the information in the application.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Motion carries.
The second item is NetPK LLC filed on May 15th, 2018, request to cancel its license to operate as an electricity broker in Maryland.
Good morning, Chairman and Commissioners. Peter Wolson on behalf of the staff. Pursuant to COMAR 240305, NetPeak seeks to discontinue its authority to broker electricity in the state of Maryland and cancel its license. The company has no current customers in Maryland, it has no outstanding complaints, and it has no outstanding Commission assessments. Staff has determined that all applicable requirements of the regulations have been met, and accordingly staff recommends the Commission rescind NetPeak's authority to operate in Maryland and cancel its license to operate as an electricity broker.
Thank you. Questions for staff? If not, do we have a motion?
Mr. Chairman, I move the commission cancel the company's license to operate as an electricity broker in Maryland.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Motion carries.
We'll take item numbers 3 and 4 together. Item 3 is Delta Energy Services LLC, filed on May 24, 2018, an application for license to supply electricity or electric generation services in Maryland. And item 4 is Delta Energy Services LLC, filed on May 24, 2018, an application for a license to supply natural gas or natural gas supply services in Maryland.
Good morning again, Mr. Chairman, Commissioners. Kenneth Albert for staff. These two items address applications by Delta for authorization to operate as a broker of natural gas and electricity for commercial and industrial customers. Their management has significant experience in the energy industry. They are operating currently in Pennsylvania. No complaints have been filed against them, and no enforcement actions associated with the company have occurred. We took a look at the website. It looks fine. Therefore, staff recommends that the Commission authorize Delta to operate as an electricity and natural gas broker.
Thank you. Questions? Commissioner Herman.
So I noticed that you referenced that the Pennsylvania Commission maintains a database of consumer complaints and that you check that. Do you have any sense of how often that database is updated?
I can check on that. It's fairly current.
It is? Okay.
We do rely. I think it's New York has a nice database. Pennsylvania has there are several states where you go right to the database. We do follow up, though. Frankly, that's what we start with, that by asking for the complaints. But we always follow up with a query saying, we checked your database, because if we don't say that, they'll say, check our database and leave us alone. So, and then, do you have any concerns, any enforcement actions, anything else going on? So my sense is we've never received feedback from them, oh, we hadn't posted this yet.
Okay. All right, great. That's very helpful. Thank you.
Sure.
Anything else? If not, do we have a motion for items 3 and 4?
Yes, Mr. Chairman, for Delta Energy Services, LLC, I move we grant the company a license to operate as an electricity supplier and as a natural gas supplier in Maryland, limited to broker services for customer classes and service territories applied for and recommended by staff, and direct the company to provide marketing and training materials specific to its Maryland operations to the Commission staff 30 days prior to utilization of the materials in Maryland, and direct the company to file notice with the Commission within 30 days of any changes to the information in the application.
Is there a second?
Second.
All those in favor signify by saying aye. Aye. Motion carries.
Item number 5 is Baltimore County Government, filed on March 28, 2018, a request for a waiver of penalties accrued due to a malfunction of heating equipment on January 5, 2018, resulting in use of natural gas during the event pursuant to paragraph 3.4B of the Schedule IS.
Good morning, Mr. Chairman, Commissioners. Lloyd Spivak for the Commission staff. Baltimore County Government requests a waiver of the penalty provisions found in Baltimore Gas and Electric Company's Interruptible Service Tariff, Gas Interruptible Service Tariff, Section 3.4. The county failed to fully cease gas usage at two facilities on a distribution service interruption day event, which triggered the penalties for failure to interrupt. The county takes gas service under Schedule IS of BGE's tariff, which requires customers to reduce their gas consumption to zero or operate within contracted optional firm delivery service amounts within 2 hours of receiving notice of an interruption. However, Section 3.4 of BGE's Interruptible Service Tariff allows customers who made a good faith effort to interrupt and meet 4 criteria to request a waiver of the penalties from the Commission. The 4 criteria upon which a waiver may be granted include efforts made prior to the interruption to be fully compliant, the reason why full compliance was not attained, such as sudden failure of the alternative fuel equipment, efforts to correct noncompliance during the interruption, and customer actions after the interruption to be fully compliant in the future. On January 5th through 7th, 2018, a distribution system interruption day event occurred, prompting BGE to send notice of interruption to its interruptible service customers. During the event, the county had 636 therms of usage, representing approximately 18% of their regular demand. With respect to the four criteria, staff's review of the county's efforts to comply with the interruption requirement is detailed in staff's comments. Staff concluded that the county has met the good faith compliance standard. Staff therefore recommends that the Commission grant the requested waiver for the county.
Your questions. We'll start with Commissioner O'Donnell.
Thank you, Mr. Chairman. I was curious how much the penalty would have cost the county had it, if we were to implement the penalty, what would it cost the county for failure to interrupt?
Morning, Chairman, Commissioners. Jason Cross on behalf of staff. The penalty would have been approximately $34,000.
$34,000. Do you know if we have do we have a backlog of these filings where interruptible customers have failed, or is this? I mean, this is two admin meetings in a row we've seen these.
We actually, this year, we had 2 filed for BG&E so far. We do have 3 from WGL that are pending.
Okay.
That's WGL.
All right, fair enough. I just let me ask you about the 4 criteria. The first criteria is what was done prior to the event, prior to the failure to interrupt, and it seems like the thing that's referenced is always a test, a pre-seasonal kind of interruption test, and they don't seem to preclude these failures. That test doesn't. There's no connection between the failure mechanism and that test, pre-seasonal. And in this case, it looks like the county has changed their operational procedure to include a valve lineup, I suppose. Will that become part of the test criteria that's done every season, or how will that work going forward? And I think the county may be here. Maybe they could answer that question.
Thank you. Greg Duran, property manager. Yes, we've revised our standard operating procedures. The event occurred following replacement of old existing boilers to 3 new boilers, and work that had been done with that left us in a situation where our previous standard operating procedures failed to observe this valve alignment. So that has been corrected. As far as the attempts, we started in December to be sure and certain that with the new equipment, this would all be able to provide operation on oil during an interruptible service. We've always met that criteria in the past. We actually switched over several hours early to make sure that we met the criteria, and our time on oil actually met the demands of the interruptible service, that we were actually on that. It's just that during the interruptible service, we had lost the ability to run on oil until we could make the corrections during the severe weather that we had at that time. We had to switch back to gas, but we did complete and go back to oil for the duration of the interruptible service event.
I understand you had enough oil in the day tank apparently to run the generator on oil, but when that ran out, the misaligned valve then shut your oil supply off.
Well, that's when we discovered it.
Right.
Following that, we pumped from a 10,000 gallon UST that pumps to the 12th floor penthouse area to day tanks. We were in operation. We had tested it. Everything had worked. That we found in that the gauges on the day tanks were wrong as well, and so where we thought that the tanks were completely full, which directed us kind of a different direction in the troubleshooting process as well.
Will the valve lineup that you took as part of criteria 4 be part of your normal pre-seasonal checks?
It is.
Besides the test, so it will become a normal part of the test pre-season.
It is, and I did bring a copy of our new SOPs.
Thank you. That answers my question.
You're very
I appreciate
welcome,
it. Thank you.
Sir, can I ask you to spell your name for our record?
Doran. Doran. Greg.
Right. Thank you. Any other questions for the county? They are here. Any other questions for our staff? All right, hearing none, I want to thank Mr. Cross for his analysis. Do we have a motion?
Yes, Mr. Chairman, I move that we grant the requested waiver.
Is there a second? Second. All those in favor signify by saying aye.
Aye.
Motion carries.
Thank you, Commissioner.
Last item.
The last item on the agenda is Clean Choice Energy Community LLC, One Energy Renewables, TPE Maryland Solar Land Holdings LLC, Community Energy Solar LLC, filed on April 10th, 2018, request for regulatory relief from Community Solar Pilot Program operational deadlines for projects in Anne Arundel County.
Good morning, Mr. Chairman, Commissioners. Annette Garofalo on behalf of Commission staff. The applicants in this case are solar entities seeking to build in Anne Arundel County. By regulations effective July 18th, 2018, the Commission adopted COMAR 2062, Community Solar Energy Generation Systems, for the purpose of implementing Section 7306.2 of the Public Utilities Article, Maryland Code. COMAR 2062 lays out the process by which entities may be qualified as community solar energy generation systems, including the role of electric companies in that qualification. As specified in COMAR 2062-0304C, the regulations provide that should a project fail to begin operating within 12 months of submission of an completed application by the subscriber organization, the electric company shall remove the project from the electric company's pilot program queue unless the subscriber organization of the project provides to the electric company an additional deposit of $50 per kilowatts to maintain its position within the pilot program queue. If a project fails to begin operating within 18 months of application, the electric company shall remove the project from the electric company's pilot program queue. And the purpose of these was to prevent what was a limited capacity that was allowed for these from being used up by companies that were not building. So the regulations provide further that the electric company is required to extend the operation deadline on a day-for-day basis if the subscriber organization attests and provides evidence to the electric company that a governmental permit or approval for the project was subject to a legal challenge during the reservation period and the legal challenge remains pending. And that's what we have here in staff's opinion. By their letter, April 10th, applicants, all of whom have commission authorization to act as CEGISs in a portion of the Baltimore Gas and Electric Company service territory located in Anne Arundel County, and have cleared BGE's interconnection queue, state that they have been foreclosed from building their community solar facilities by a moratorium adopted by Anne Arundel County after applicants had received authority to operate as CEGISs. In resolution of the matter, applicants ask that the Commission find that the Anne Arundel County moratorium consists of a pending legal challenge under COMAR 2062. In the alternative, the applicants request the Commission grant waivers of COMAR 2062-0304C for the Anne Arundel County projects pursuant to 2062-0104, which is would allow you to waive the application, the regulations for good cause. Staff agrees that applicants should be granted relief. Applicants have proceeded in good faith to timely apply for and have been successful in receiving CEGIS numbers from the Commission and in applying for interconnection agreements from BGE. They have conducted pre-construction field studies, met with the county whose applicable zoning requirements they were familiar with prior to applying for consideration as CEGISs. Applicants state they have proceeded in good faith to complete development of the projects in a timely manner in accordance with state and county law. And staff finds no reason to doubt this statement based on the record in this matter. One cannot know with certainty whether over time these projects might have been delayed for some reason other than the moratorium. However, at present, the evidence indicates that that is the sole matter which is preventing their completion of these projects, and this is outside of applicants' control. Staff recommends the Commission direct BGE to treat Anne Arundel County's moratorium as a legal challenge that prevents applicants from completing timely development of their CEGISs, and extend the deadline for applicants' completion of the projects on a day-for-day basis, with payment required under COMAR 2062-0304C1 to be due after the equivalent of 1 year from the date applicants are able to begin development anew.
Thank you, Ms. Garofalo. First, we'll take questions from staff, but Mr. Chasen, why don't I ask you to come to the council table with anyone else you would like to bring, because I'm sure we're going to have a few questions for you. And we'll start with Commissioner Herman, then Commissioner Richard.
So, Ms. Garofalo, is it necessary for the commission to find that this is a legal challenge, or is it equivalent to say to just grant the waiver? Is there equivalency there?
Well, there's not, it's, granting the waiver would be broader than finding it a legal challenge. The legal challenge still requires them to complete these projects within the equivalent of a 12 to 18-month period, and it keeps them within the regulations. This is something that was foreseen, and in this case, there's the moratorium is not without end. It ends, I believe, August 3rd. And I think the applicants believe they can complete timely what they have begun.
So, but if the commission were to grant the waiver and put 12 months on it, for example, would that solve the problem of the timing issue and being outside of the regulation?
Well, I think you could do that. You could do that. I think the main thing that's being asked for here is more time.
Right.
And so, with that, you would be giving them that aspect, which is
Within a specified time period, similar to what's in the in the regulation.
right.
Right. So the other question I had about your motion or your recommendation is, you say to be due with after the equivalent of 1 year. I'm not sure I understand what that means. A year is a year, and I'm not sure what the equivalent of a year is.
Well, I don't have in front of me the applications from these CGSs. However, they did apply to the commission, and that started the clock running. And at the time they applied and went into the interconnection queue of BGE, there was this moratorium was not in place, so they did do some initial work, which I think is described in the application, is described briefly in staff's comments. So this would be a day for day. If you didn't do the entire waiver and you followed you would be giving them a day-for-day extension. So it would be, I believe it's 6 months extension, but it would begin on the date of the moratorium. Actually, we don't know exactly when it would begin, because it could be that the moratorium would end and they wouldn't accept applications for 30 days while they were getting things in place. So a little bit of their year has been used up, and I'm sure Mr. Chasen can tell you how much of that time has been used up.
So it wouldn't be a year. I guess I'm just really confused by the language equivalent of a year from the date they're able to begin development anew.
Right.
To me, there's two sort of fuzzy phrases here. The equivalent of 1 year, which I'm not sure I understand, and then able to begin development anew. What does that mean? Does that mean, is that, I mean, because if the county held it up for 2 years, does that mean that, that this 1 year period doesn't start until the county, so the county's ready to take an application, so I'm just really confused by the timelines here.
So I think they got their application in July, and I can see from the corner of my eye that Mr. Vanderheyden is going to help me out. But just from a legal standpoint, if 3 months of their 12-month period has already elapsed, then you would be giving them 9 months extension.
That's your intent.
That's the intent, to give them the full amount of time they would have within the regulations. But let me, Mr.
Vanderheyden perhaps can help.
Even unfuzz that, including the math, if I did the subtraction.
Okay, thank you.
Good morning, Mr. Chairman and Commissioners.
Morning.
In terms of the clock starting on the 12-month initial period to complete construction, that starts when the applications to get into the program are complete. And I think that would have been last August when the projects came out of the interconnection queue, and then they then presented to get into the project, they need the interconnection agreement, they need site control, and they need proof of applicable permits. So what's being blocked here is the permitting process at the county level. It can't be completed, or they can't move forward if they have a moratorium on construction. So the clock would have started when they were awarded project capacity in this case, the BG&E program. And I think what we're trying to accomplish here is having that clock starts running. They have 12 months to complete it. If they don't get it within 12 months, they can extend it by paying a deposit of $50 a kilowatt, which would give them 18 months from the date the project was accepted into the program, and they were told by BG&E, your project's in, start building, or proceed. But what we're trying to accomplish here is this moratorium is effectively stopping them from proceeding. So we want to essentially stop that 12-month clock and then restart it when the moratorium comes off without adding any additional time other than what the moratorium left in place. So we want to have a total of 12 months of time to complete construction, but we want it to be paused essentially while the moratorium is in place.
Okay, so if the commission were to grant a waiver of the regulation, Section C of the regulation, and I believe the moratorium was an 8-month moratorium, and say that it was 8 months, the extent of that, they have an 8 months from the date the moratorium ends. Would that keep the 1-year period?
I hesitate to answer that as a yes without laying that out on a timeline and trying to sort it out. I think what we had built into the regulations the idea that this sort of thing might happen, but it was thought of as a legal challenge perhaps at the zoning level where someone might sue to stop zoning from being granted or something of that nature. I don't think we at that time had contemplated that there might be a county or jurisdiction where there was a moratorium. So I think we would like the regulations to operate kind of functionally the way it was thought of at the beginning, and that means saying this type of moratorium represents a legal challenge that allows us to kind of continue to let the regulations operate as intended. If we waive the regulations, I think it may create some perhaps additional uncertainty as to whether or not the 12-month clock applies at all, or then what happens when we reach 12 months and then we want to apply a deposit in order to stay in the program. And I think there's also potential uncertainty as how this would be dealt with in other jurisdictions that may also put a moratorium on, or if we actually have a legal challenge. So I think the cleanest way to do it is to accept that the moratorium represents a legal challenge, and then the regulations can function the way they originally envisioned. If you were to waive them, you probably have to waive them by adding some types of conditions that would require, I think, for us to think about, adding up all the time to make sure no particular project was disadvantaged or advantaged. So I think we could probably craft a waiver if you preferred to go that way, but I really would want to sit down and think about precisely how, if you would waive it for a specific amount of time, because I don't think that allows, I don't think we've plotted it out that way so we would with certainty determine that would not disadvantage these projects and or create a precedent that wouldn't fit into the way we thought this was going to work for everyone.
Right, and I guess part of my concern is that, and in your discussion, I think you went there, was that this isn't, I'm having trouble fitting this into a legal challenge. An 8-month moratorium, calling it a legal challenge, I'm having trouble from a legal standpoint saying that fits that regulation, and therefore, without having to make a finding and having a precedential finding and so on and so forth, with respect to this being a legal challenge, therefore, and we have a waiver provision. So I'm leaning toward trying to maintain the regulation in the 12-month period, but at the same time not having to make a finding that this is a legal challenge, because I think it strains, at least in my mind, it strains the meaning of those words, and so I'm kind of having an issue with that.
I understand it. I think if you would prefer to go that way, we might want to take a little bit of a step back and think very carefully about how to word that waiver so that it didn't, change, so that the program could operate the way the regulations change. I see what you mean in that you don't want to use the words, describing this as a legal challenge, but I'm trying to figure out if we can come up with a good way to make the regulations function the way we expected, even though.
Okay. And is there any, if we were to defer it and give you the opportunity to do what you suggest, are there any issues with timing associated with the projects that's going to do something that's going to harm them?
Let me interrupt you. Great question, Commissioner Herman, and before Steph answers. So my preference would be not to defer this, but we can, if we need to recess for 15 minutes, just keep this in mind, for staff and council and our executive secretary to think about that. We can do that. Yeah.
Okay, thank you. I'm just trying to understand, because to me, I've explained my issue, so I'll let some of the other commissioners ask questions, but that's kind of, a concern that I have with respect to the recommendation staff has made.
Okay. Thank you, Commissioner Herman. Commissioner Richard?
Yes, thank you, Mr. Chairman. Yeah, I'm very sympathetic to this situation, but given that this is in the context of community solar, which is a pilot program, and is I guess, if I remember correctly, is intended to take place within a discrete 3-year period of time. As staff, are pretty certain that Anne Arundel County is going to work through all its issues, and that this project will be allowed, or will projects be allowed within the context and the time frame of this pilot project?
So certain's one of those big words, even though it's not 4 letters.
And there's always uncertainty, but I just don't have any sense of where Anne Arundel County is going.
But Anne Arundel County has filed a letter stating that they do not oppose Clean Choices being granted, well, they do use the word waiver, from the time requirements. They do go on to say the letter should not be interpreted as an application of approval or endorsement of Clean Choice LLC. I don't know, if I were writing the letter, I might put that in myself, simply because I don't know exactly where all the zoning requirements are going to come out, which Anne Arundel County is working on right now.
Okay, so staff has considered this, and at this point, we shouldn't be, we should be considering maybe just taking Anne Arundel County out of the pilot project for the time being, and you think that Anne Arundel County will be able to get whatever issues resolved?
It is a moratorium with a specific time frame. I think it expires on August 3rd. And in addition, although we did try and speak with Anne Arundel County, the most we could get was a copy of their letter. But I think that I think they plan to be done within the time frame they've set for themselves. They had very clear zoning requirements prior to the community solar facilities being granted authority, and it was after that, perhaps because a new zoning commission was formed within the county, that this moratorium went into effect. So we don't know what they'll come up with, but we think that they'll be done in August.
Okay, well, fair enough. And I don't know if the staff is in a position to know this, but are there other projects that would be ready to go? Does it preclude perhaps another project that maybe has not, was not successful in the first round to move up in the queue? I mean, are we?
We looked at our list, and we did not list the projects by county, and so we probably should go back and do that. But I would recommend that if there is another Anne Arundel County facility, that they be treated similarly, even though they may not be a client of Mr. Chasen's, or they may not be before you today.
Okay, well, fair enough. And then finally, a report is due to the legislature. Is it the 2019 or the 2020 legislature? Do you recall?
I believe July 19th.
19. Okay. Are we? Is this going to cause any problems with providing a meaningful report to the legislature by delaying a project of this magnitude?
If we don't have as much data from projects that are held up, obviously that would not be something we could incorporate within the report we'll file next year, but I don't know that we would continue to collect all of that data and follow up as soon as we can.
Okay. Well, thank you for your answers.
Commissioner O'Donnell.
Thank you, Mr. Chairman. I wanted to pursue a little bit of a different line, and I'm very sympathetic to CSEG's process, and I personally want it to be successful, but I want to understand a little bit about the intersection of local zoning authorities and the preemptive authority and broad authority we have to implement the public utility article, and specifically our siting authorities, and how those two make kind of butt heads. And we've seen different iterations of this. So I'm speaking generally about what authorities local governments have here. We had a case recently in Frederick County that we decided where the county came in behind, and the developer had a material interest in their approvals, their permitting, their application, and then the county government came behind that and implemented regulations, and then claimed that the development could not go forward. I'm generalizing that case. So what is the limitation on a local government? In this case, they issued an 8-month moratorium, but what prevents the county from extending that moratorium, reissuing it? Oftentimes, local zoning ordinances get delayed for some reason, get set on the table for a year until other considerations locally are taken into account. Could the local government come in and reset this moratorium for another 8 months? That's a limited duration moratorium. It's not forever. Do they have that authority?
Well, I think they do. I think that the thing that we would look at in establishing something like a moratorium would be, is this, or a new zoning ordinance, is it targeted? Is there something specific that the county is looking at? As I'm sure you know, we do have some precedent that applies to, I believe it's transmission lines, but it does not apply to a small generating station such as it is at issue here.
So if, say we issued a CPCN for a 4-megawatt solar development, and then the county, the local government comes behind that issuance of the CPCN and declares a moratorium on that development, or that type of development for a ground array solar installation. Can they do that? Can they kind of trump the preemptive nature of our siting authority?
They may not be able to do that after the fact. We would probably need to do some research on that.
So this feels like that's what they did in this instance. They kind of, it wasn't a CPCN and it wasn't as clear cut, but it feels like they preempted, the local government kind of preempted our authority to implement our regulations in the public utility article.
It could be, I can see that it could be viewed that way. And of course, we won't know until the new county regulations are out, whether it was that or it was just tidying up the edges.
Right. I mean, the local zoning regulations, planning and zoning ordinances could preclude this development permanently, I suppose, if they made them restrictive enough.
Well, yes, they could. In this, I'm talking only about this case. I don't think that's going to happen. We have one never knows how these things get started, but there certainly were a number of environmental organizations did ask for zoning changes that would deal with how the facilities looked and were shielded from the road. And many of these organizations, if not all, have now filed letters of support of the applicants. So, but that's limited to this case, and I understand that your concerns are broader.
Yeah, I'm just, and it may not be fair to ask you to give me a sense of the limitations of local government to impact our orders and our siting authority and our ability to carry out the public utility article, but there's certainly an intersection here, and we see it play out in a lot of different respects.
We did have some cases that dealt with the application of the Forestation Act, but I believe that is a state act, but it gives some authority to the counties.
When we get to Mr. Chasen and the applicants here, maybe Mr. Chasen, since he has a good deal of knowledge in this area, can help my understanding as well. Thank you, Mr. Chairman.
Thank you. Anything else for staff? We can always come back. Mr. Chasen, welcome. Thank you for being here. Why don't we start with, if you would like to address any of the questions asked to staff counsel, and then we'll see if we have additional questions.
Sure. Good morning, Your Honors. Todd Chasen on behalf of the applicants here. I won't try to list them all. There are several of them, but they're all here, and I'm here on their behalf today. There were a few different questions that were asked, and I can kind of go down the line. They'll all go in reverse order because I can remember the last one better. To Commissioner O'Donnell's question, the dividing line is 2 megawatts. Interestingly, the cutoff for community solar projects is 2 megawatts, none larger than that. And so under the regulations that the Commission has in place, everything that is under 2 megawatts is left to the local jurisdictions. Everything that is over 2 megawatts, that's where your preemption comes in and where this Commission has authority to overrule essentially what the local jurisdiction wants to do if the Commission decides to do that. I think there are a couple of different questions within what you were asking, if I was hearing it correctly, and it also goes to Commissioner Richards' question, which is that based on the information that we have, we do expect that Anne Arundel County's moratorium will be of limited duration, that it will come to an end in August or shortly thereafter. One clarification is that we need to get not just past the end of the moratorium, but also to when they begin processing applications again, because there may well be a little gap. Maybe, I think we said 30 days within here, but just a recognition that moratorium ends and then they've got to ramp the machine up again before they get going, and we would want to include that 30 days. But our expectation and our hope, and developers are optimistic people by nature, is that this moratorium will be lifted, and then the local jurisdiction will review these projects on their merits, and then we'll decide one way or the other. To Commissioner O'Donnell's question, because these are fully within the jurisdiction of the local authority, they could, in reviewing these, they could, in their local zoning ordinances, decide that they don't want these projects in these locations, that they don't want projects generally in certain locations, and because of the regulatory structure, they are left to their own devices there. Unlike the CPCN cases, the more than 2 megawatt cases where, and you were referencing one of the cases in Frederick County, it's a different story there. Ultimately, the Commission can decide whether it wants to give deference to the local jurisdiction, but it's really a question of who's the decider. In these sub 2 megawatt cases, it is the local jurisdiction that's the decider. It is ultimately the Commission that decides in the cases that are over 2 megawatts. So I hope that is responsive to your questions. And I fear that I can't completely remember the line of questioning from Commissioner Herman. If you'll help my memory, maybe?
Certainly.
Thank you.
So, one, I had some questions about, whether this fell within a legal challenge. And then the other question I have is, if do we have to call it a legal challenge, or because you asked in the alternative for a waiver, so what's the difference between the two, if any, and for how long would that waiver need to be issued? Trying to keep in mind that we're not trying to advantage or disadvantage your clients. If that were our goal, to keep within a 12-month period. So for how long would that waiver be in place?
Sure. Thank you for refreshing my memory. I think both roads lead to the same place. and we are agnostic as to which one the commission chooses. You could call this a legal challenge and have the regulations function as Mr. Vanderheyden explained, or you could say, we don't quite think that this fits in within the idea of the undefined term of legal challenge. We'd rather use our waiver authority. We ordered them the way that we did because, frankly, administrative agencies are usually a little reluctant to go the waiver route. They prefer to stay within the regulations if they can rather than waiving provisions. But I don't think that it makes any difference from our perspective. And I think that if the commission is more comfortable with the waiver provision, that it could do exactly the same thing using that provision as using the legal challenge. I think Mr. Vanderheyden was trying to explain you would basically just say we intend for this waiver to operate in the same way that that section of COMAR was designed. So essentially that pause button day for day from the time that it was first put in place in December until they begin processing applications again. Whatever time elapsed from application to the beginning of the moratorium would be counted against that 12-month period. The pause button's hit, and then it becomes December 4th when they start processing applications again. When 12 months have run, then if they have gotten to that point and they are not in operation yet, then the regulations revert back into place. They can decide whether they want that get-out-of-jail-free card where they pay under Section A and move forward from there if they get to that point. So I think it's fairly easy to articulate we'd prefer to use the waiver rather than the legal challenge, and to have it operate the same way that the legal challenge regulation is designed.
Okay, and if the commission were not comfortable saying until the county starts taking applications, would we then say 8 months plus 30 days, or, in order to try to maintain, but to not harm, but also not advantage your clients with respect to the time period, the 12-month time period?
And we thought about, in our request, how best to go about that, because, of course, we're balancing the unpredictability. Maybe it's going to be August the 5th, maybe it's going to be some other period of time, with the commission not necessarily wanting to see me before you on this issue again anytime real soon. As I was listening to Commissioner Richards' question, what I was thinking was that what you may want to say is to grant our request, but say that if, say, the moratorium remains in place on October the 1st, then you'd like for us to come back before you, and then you could reevaluate, so that you're not giving us an unlimited time if the county indeed does keep this in place forever or for some long period of time. So, of course, the commission always retains jurisdiction over us and could always bring us back in again. I'm just trying to think of a way to articulate it that allows a little bit of wiggle room, recognizing that things don't always happen exactly as planned, and I wouldn't want it to, say, be September the 1st when this gets lifted, and then the 30 days, and we've essentially lost another month.
Right.
So I'm trying to come up with a solution that addresses that concern, but doesn't necessarily mean that in the next 2 months I'm going to have to come back before you.
I understand. Thank you very much.
Commissioner O'Donnell.
I just wanted to, I think I heard you say that they could keep this moratorium in place indefinitely. Is there any limitations? I think I read in here that it has to be of limited duration and a reasonable length of time. But I think I hear you say that maybe they could keep this in place indefinitely.
So I think your question begins to touch on this notion of why this might not arguably be a legal challenge, that it could be something else, is that when we think of legal challenges, we think of appeals. We think of things that have deadlines to them. If we're going to appeal a decision of the public utility law judge, there's a period of time for the appeal, there's a period of time for then the decision. If there's not a decision, so on. Because of the fairly unlimited authority of the local jurisdiction here, as I was explaining before, in theory, now there's no reason to believe they're going to do this, but they could well decide that they want some additional time to think about this. I think I think Caroline County, maybe they had a moratorium in place on all projects back in December. They wanted to have one more meeting about it, so it was later in December before that moratorium was lifted and their new ordinance went into place. So I think because they have more or less unfettered discretion, the answer is they could well decide that they want to do something more than that. But I don't have any reason sitting here today to believe that they will.
Yeah, I'm asking more generally beyond the confines of this particular case. So you're saying that a local government generally could indefinitely institute a moratorium?
I think, and I'm sitting here answering off the top of my head, but I think on projects that are under 2 megawatts, the local jurisdictions can do what they want. They could replace the moratorium with a ban, I think. They'd have to go through that local process. They have to go through and follow the due process requirements that go along with local process. And I'm familiar with local process based on my practice, but I'm not a land use attorney by any stretch of the imagination. But I think they can do almost anything that they want.
Do your clients have a material interest, a legal material interest in their applications so far? In other words, that is being denied by the county via the moratorium?
Do they have a vested right? Is that the question? Ordinarily, vested rights at the local level actually require work to be done. Like, you have to have started your project. You have to be quite well beyond having submitted an application for rights to have vested in a project like this.
I think in a previous case we had where the appeals board at the local level had issued a variance, and there was a vested right in that variance, I think.
My recollection of that decision is that the commission decided that it was far enough along for the commission to consider it to have been vested. I think it depends on the definition in the context of vesting. I think.
Thanks. I appreciate your answers. I'm really just trying to understand this generally. I'm supportive of however we craft the waiver. I just I want to understand. It just doesn't seem like being a former state legislator for a couple decades, it doesn't seem like local government should be able to trump state policy, but I guess they can in this instance.
I don't know if you want me to respond to that or not.
It's okay. It's rhetorical now.
Thank you.
Commissioner Linton?
Yes, thank you, Mr. Chairman, and good morning.
Good morning.
Have you or your clients had an opportunity to see what types of proposed changes or regulations the county is looking to present?
So my understanding, and if I get this wrong, one of them will hop up, but there's an ongoing process that they have all been participating in and trying to provide feedback in. I don't think that it has yet materialized into any sort of either final proposal or late draft, but I think that they are continuing to participate in that. Is that fair?
Yeah, I believe there's a report completed already.
Sure, why don't you introduce yourself for our...
Yeah, sure. Solar Naini with TP, representing TP Maryland Solar Land Holdings.
Great, and can I ask you to spell your last name for us?
Sure, Naini.
Thank you.
Yeah, so the Anne Arundel County put together a working group consisting of various stakeholders to look at this particular issue, which all of us have been participating in. And they've just issued their report and a recommendation to the county executive, and so I believe that basically there's the county executive. It goes back to the county council to ultimately make that decision. So we do kind of see there is forward momentum on coming to a decision here in the next couple months.
And so the applications that you've submitted, according to the letter that the county submitted, or at least presented back in December, item number 3 says that the applications that are currently submitted are going to be subject to the new regulations or new procedures that the county is looking to adopt. So since you've seen those, or at least you've seen the report, where are we in terms of the current applications you have versus the new regulations? Are you going to have to refile? Are you looking at starting over truly from scratch? Or are what you've already filed sufficient to meet the existing and the new proposed regulations that's in the report?
Sure, that's a great question. I think the report has been more conceptual rather than outlining a specific process. They have mentioned changing it from there was a conditional use. It was a conditional use permit process. As long as you met the conditions, you would get your permit. And now they're looking to change it to more of a special use permit process. That's but it's been very high level. They don't have like specifics of how that'll actually work. I think that's kind of up to the county council. The report goes back to the council, and the council ultimately put those regulations together to know exactly how that process will work.
All right, this might be a question for Mr. Chasen. From the, we're in June now, and this is supposed to be an 8-month moratorium. So sometime in August, these regulations or whatever new changes the county looks to adopt should be in place. So from a process perspective, do you know, or do your clients expect that the county is still on track to meet that August deadline? We're just talking about a report now. What's their regulation adoption process? How much are they going to finish in 2 months, basically?
So we don't have a ton of insight into that. When it's I believe June 13th, and we're talking about less than 2 months away over summertime, I agree with you that there's some reason to wonder whether that's really going to be in place by early August. And I think it goes back to my response to Commissioner Herman, which is that I don't think that there's nothing that we have before us to suggest that it's going to be indefinite. But it would not surprise me at all if there was a little bit of lag and it wasn't quite August 3rd by the time it was done. But that's somewhat speculative.
All right. So where does that leave this, the potential waiver, assuming that the commission grants it then? If the county's not completed with the process, could they just extend the moratorium for another 6 months to continue working on it? What happens to your pending applications that are sitting there?
So it depends on how the commission words the waiver grant, assuming that you decide to go that way. And the way that my request is that you would grant us a waiver of those provisions until the expiration of the moratorium and they begin processing applications again. As I responded earlier, one thing you could do to provide some backstop to that is to say, but not later than October the 1st or some date this fall, without further, application from us, so that you'd at least have an opportunity, if it turns out that it really is into the fall and they haven't put these into place, they haven't started having regulations that we can operate under, it gives you an opportunity to ask me these same questions, to have staff continue to talk to the county and try to get a sense for what's going to happen.
Okay, thank you. Thank you, Mr. Chairman.
Anything else from Mr. Chase? And Ms. Groplow, anything you would like to add?
Nothing further, Your Honor.
Why don't we do this? My preference, I think, would be to ask our executive secretary to work with Ms. Groplow, certainly with the input of Mr. Chasen, on a draft motion for us to consider. Commissioner Herman, if you want to give some guidance more beyond what you've already given, that would be helpful. And we'll recess for 15 minutes, and then we'll come back.
Certainly.
Sure.
Thank you, Mr. Chairman. It sounds like I think that the staff and the executive secretary and the companies hopefully can reach agreement. I think what for my part, I'd like to maintain the timeline, the 1 month, without. We want, again, sympathetic to the companies to try, to accommodate the moratorium without harming them, but without giving them an advantage over other entities in the state. So that's I'd like to go there. And with respect to the waiver and trying to bring us all to the right place, and I do like the concept that if the moratorium is not lifted by, I think October 1st is a reasonable time frame, because it was supposed to be in August. That gives them an additional 2 months to come back and give us a status report, and we can reconsider it. So for my part, I think that that is a helpful
All
suggestion.
right, thank you. That's some general guidance, I think very helpful. Any commissioners, any other guidance? All right, great. We will recess for 15 minutes. We'll be back at 11:20, and we will take up a motion. Thanks.
Thank you.
Okay, welcome back, everyone, to the Maryland Public Service Commission's administrative meeting. We return to item 6, and let me turn it over to Ms. Garofalo to see if she has a recommended motion for us.
I do, Your Honor, but the Executive Secretary has the exact quote, but we were able to reach agreement, and we have a motion for you.
Okay, great. We have it before us. Any questions on the motion for Ms. Garofalo or anyone else? All right, if not, Commissioner Herman, would you like to make the motion?
Thank you, Mr. Chairman, and thank you to the parties. Mr. Chairman, I move we grant a waiver of COMAR 2062-03-04C1 and 2 for these applicants' Anne Arundel County projects for good cause shown. Direct BGE to extend the operation deadline for these Anne Arundel County projects on a day-to-day basis from December 3rd, 2017 until the earlier of 30 days after the end of the moratorium or October 1st, 2018, and direct applicants to file a status report by September 17th, 2018 if the moratorium remains in effect on September 1st, 2018, and the applicants may request a continuation of the waivers.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Motion carries. I want to thank Mr. Chasen, Ms. Garofalo, Executive Secretary Romine for your assistance. I'm very happy to have this motion offered and passed. Thanks, everyone. We are adjourned.
Thank you very much.